5 seconds to go. Start. Defendant accused deliberately gave the above check with intent to grab complainant's money, which has been dishonored in the bank. Thus, defendant accused is guilty of committing offence under Negotiable Instruments Act. Therefore, you are requested to summon the accused and punish him with the directions to pay the complainant the double of the above check amount under provisions of NI Act. Complainant shall remain obliged to you. The question whether it is necessary to specifically state in the complaint that the person accused was in charge of or responsible for the conduct of the business of the company was subject matter of reference by a two-judge bench of this court, along with other questions to be adjudicated by a larger bench. The following questions were referred for consideration: whether for purposes of section 141 of the Negotiable Instruments Act 1881 it is sufficient if the substance of the allegation read as a whole fulfill the requirements of the said section, and it is not necessary to specifically state in the complaint that the person accused was in charge of or responsible for the conduct of the business of the company. Whether a director of a company would be deemed to be in charge of and responsible to the company for conduct of the business of the company, and therefore deemed to be guilty of the offence unless he proved to the contrary. Even if it is held that specific averments are necessary, whether in the absence of such averments the signatory of the check and or the managing directors or joint managing director, who admittedly would be in charge of the company and responsible to the company for conduct of its business, could be proceeded against. A three-judge bench in the case of SMS Pharmaceuticals Limited versus Neeta Bhalla Supra, considering the aforesaid questions after analyzing the provisions of section 141 of the Act, and especially the words who at the time the offence was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offence, etc., used in the said section, observed as under. While analyzing section 141 of the Act, it will be seen that it operates in cases where an offence under section 138 is committed by a company. The key words which occur in the section are every person. These are general words and take every person connected with a company within their sweep. Therefore, these words have been rightly qualified by use of the words who at the time the offence was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offence, etc. What is required is that the persons who are sought to be made criminally liable under section 141 should be at the time the offence was committed in charge of and responsible to the company for the conduct of the business of the company. Every person connected with the company shall not fall within the ambit of the provision. It is only those persons who were in charge of and responsible for conduct of business of the company at the time of commission of an offence who will be liable for criminal action. It follows from this that if a director of a company who was not in charge of and was not responsible for the conduct of the business of the company at the relevant time will not be liable under the provision. The liability arises from being in charge of and responsible for conduct of business of the company at the relevant time when the offence was committed, and not on the basis of merely holding a designation or office in a company. Conversely, a person not holding any office or designation in a company may be liable if he satisfies the main requirement of being in charge of and responsible for conduct of business of a company at the relevant time. Liability depends on the role one plays in the affairs of a company and not on designation or status. If being a director or manager or secretary was enough to cast criminal liability, the section would have said so. Instead of every person, the section would have said every director, manager, or secretary in a company is liable, etc. The legislature is aware that it is a case of criminal liability, which means serious consequences so far as the person so to be made liable is concerned. Therefore, only persons who can be said to be connected with the commission of a crime at the relevant time have been subjected to action. A reference to subsection 2 of section 141 fortifies the above reasoning because subsection 2 envisages direct involvement of any director, manager, secretary, or other officer of a company in commission of an offence. Stop.